Greetings, everyone. I am Ngabuto Nicholas Mabena. We are discussing the rejections of the Zimbabwe exemption permit holders. You will know that ZEP holders are moving to other visas as advised by the government of South Africa through the Department of Home Affairs. We are discussing in this video legal analysis. Luke Othuzen, a researcher at the Helen Suzman Foundation, has written an interesting article on Dale Maverick, which we are discussing so that we might have a better understanding in terms of the holders of ZEP who are applying for waivers and then apply to move to other mainstream visas. The article was written on the 23rd of July, 2025. You might want to Google the article. It starts by saying, for Zimbabwean exemption permit holders, we have lived in uncertainty for years. This is just the latest wrinkle in their plight. The is this article the title says Zimbabwean exemption permit visa rejections expose legal uncertainty in South Africa's general work visa regime. As the government continues to grapple with the future of the Zimbabwean exemption permit ZEP, many ZEP holders have been encouraged to apply for mainstream visas, such as the general work visa. You will recall that the minister appointed the Immigration Advisory Board, amongst others, to advise him on what to do with the Zimbabwe exemption permits. Earlier this year, the Helen Suzman Foundation, HSF, received a report of a ZEP holder who applied for such a visa with the support of her employer. She had secured a ministerial waiver issued through Immigration Circular 7 of 2024, exempting her from one of the technical requirements usually required to obtain a general work visa. You will know that if you are not a holder of an exemption permit or Lesotho special permit, you need to get a letter from the Department of Labor, and your qualifications must be evaluated by the South African Qualifications Authority. The article continues, yet to her surprise, the Department of Home Affairs rejected her application, citing non-compliance with the very requirement that the minister himself had waived. When she wrote to the Helen Suzman Foundation, her story did not seem unusual. Another case of departmental confusion about the status and policies of the ZEP. However, upon further investigation, a deeper concern revealed itself. She was rejected in terms of Immigration Regulation 18, subsection 3, subsection B, which requires applicants to submit proof of their qualifications as accredited by the South African Qualifications Authority. But what if Immigration Regulation 18, subsection 3, subsection B no longer exists? That's the question. So the author then goes on to answer and give clarity to this question. Regulations, like other forms of legislation, may from time to time be amended or repealed by the government. When governments intend to amend or repeal regulations, this is done via the publishing of government gazettes. The immigration regulations that control processes such as the general work visa application were originally issued in 2014. Under those regulations, applicants for a general work visa had to comply with the 5 requirements listed in Regulation 18, subsection 3, subsection A to subsection E. Those requirements were a certificate from the Department of Labor confirming that the applicant's employer had been unable to find a suitable South African or permanent residence for the position, that the applicant was qualified for the position, that the salary was not below market standards, and that the contract met local labor norms and was conditional on visa approval, being proof of their qualifications as accredited by SAQA. C, the full particulars of the employer. D, an undertaking by the employer to inform the Director General of the Department of Home Affairs if the applicant breached their visa conditions. And E, an undertaking by the employer to inform the Director General of the Department of Home Affairs if the applicant ceased to be employed or changed roles. In 2018, the immigration regulations were amended for the first time. Importantly, Regulation 18 was amended. The language of the amendment was, in quoted marks, Regulation 18 of the regulations is hereby amended by the substitution of sub-regulation subsection 3 of the following sub-regulation, close quoted marks. The amendment then listed only new 18 subsection 3 subsection B with no sign of the previous requirements found in subsection B to subsection E. On a literal reading, it will appear those requirements had been repealed, no longer existing in law. That, of course, would create an incredibly relaxed visa application process, something that seems unlikely to have been the intention of the DHA. But how would ZEP holders or any other applicant know this? The government does not frequently publish consolidated legislation and regulations which incorporate new amendments. Instead, it often publishes government gazettes containing such amendments and leaves it to the public to incorporate changes themselves. As such, the language of these government gazettes carries the authority of the law. They tell us in plain language what the law is. So, why then is it the DHA's position that subsection 8, section 18, subsection B, 3, subsection B to subsection E still exists in law? No further amendment to the immigration regulations has written these requirements in, yet the Director General of the DHA assures the Helen Suzman Foundation that Section 18, subsection 3, subsection B continues to be operational and enforceable and was never repealed. A quick search on the DHS website confirms this position, where a document titled New Immigration Regulations appears to incorporate the 2018 amendments into the 2014 regulations. It is important to note that several amendments have been made since 2018, though none of those finds a place on this document. The document lists Section 18, subsection 3, subsection A to E, with an important footnote that states that the instruction in the Government Gazette is to substitute subsection 3, but the department has informed us that the intention was to substitute paragraph subsection A only. The use of the third person, that is the department has informed us, as quoted by the author, suggests that this document was not compiled by the DHA. More importantly, there appears to be an admission by the DHA of the ambiguity here. It is, frankly, absurd that the only indication that these requirements have survived the amendment can be found buried in a document, unlikely to have been compiled by the DHA or any other government source as a footnote. For 7 years, general work visa applications have proceeded on certain legal footing. No government gazette has cleared the issue, despite several opportunities to do so. The latest amendment to the immigration regulations, gazetted in October 2024, even amends later subsections of Regulation 18, but does not mention subsection 3. If the department knows about the ambiguity, why hasn't it clarified the law through Government Gazette? For ZEP holders, we have lived in uncertainty for years. This is just the latest ring in their plight. Regardless of the legal footing of Section 18, subsection 3, subsection B, they've been granted a waiver which clearly prohibits the department from rejecting their general work visa applications for non-compliance with Section 18, subsection 3, subsection B. The DHA has assured the Helen Suzman Foundation that such rejections should not be taking place and that aggrieved ZEP holders may simply exhaust the internal appeals process to ratify such decisions. In the case of the above ZEP holder, the one that was rejected, her carefully crafted appeal citing the minister's waiver has not been abjugated, despite her lodging it more than 2 months ago. And of course, many have waited for over a year or two, even as from 2022. Her example is not an isolated case. The Helen Suzman Foundation has received several similar reports from ZEP holders facing rejections in terms of regulation, section 18, subsection 3, subsection B. She, along with thousands of other ZEP holders, must continue to live under extraordinary pressure with the ever-looming possibility of deportation hanging around her neck. But this issue is bigger than the ZEP. It implicates every single general work visa decision since 2018. The simple question is, what is the law? If regulations, section 18, subsection 3, subsection B to subsection E have not survived, what is to be done about those 7 years of decisions? Retroactively, invalidating every general work visa decision since 2018 would create an administrative nightmare at great cost to the state. This ambiguity may even confound our courts. What order will serve justice on aggrieved applicants without crippling state capacity? Ultimately, it cannot be to individuals to guess at the true intentions of the DHA. In a constitutional democracy, the law must be accessible and comprehensible to all. It should not require deep investigation and guesswork. In this circumstance, the DHA must clarify the law in the appropriate manner through a government gazette, which clearly reintroduces the requirements into Regulation 18 of the immigration regulations. More importantly, this country must reform the manner in which the laws are presented to the public so that individuals have easy access to consolidated legislations and regulation. That is the end of the article written by Luke Ostizen, who's a researcher at the Helen Suzman Foundation. So this letting that the author speaks about, like many others that we have seen, was rejected. But of course, we must also point out that there are also many that have received their general work visa we seem not to understand, because you will get, which we have seen, a domestic worker who applies, gets granted a waiver, applies for a general work visa, gets granted the general work visa. You then have another domestic worker, which I suspect this one might be a domestic worker, who applies for the same general work visa after being issued with a waiver, but the application gets rejected on the reasons stated in this article. So two people uh, under similar circumstances in terms of the work they do, one gets granted, one gets rejected. So that's the in our view, the confusion that we see, and we seem not to understand why this is. We also have seen some people with their waiver applications being rejected, others being granted. So we seem not to understand what is happening. We hope that the department will clarify all these issues, because if a person has applied for a waiver and has stated what they request the department to waiver, the waiver gets granted. One then has a feeling that this person's application will sail through. What we have seen in some instances is that the general work visa gets rejected on the basis that the applicant did not meet the requirements which were waived in the waiver in possession of the applicant. So that's where the issue is. Comrade Mandla Dow says he's still waiting for a waiver outcome since February 2023. You are not the only one. There are quite a number. We remember we've been saying that last year the minister had promised us that by 31st of December 2024 they were going to deal with the backlog. I remember there was some kind of celebration that indeed they dealt with the uh, backlog, and we expected that from January the process was going to be smooth, which we think that an application must take about 8 weeks to be processed. But it seems that is not the case. Comrade Luke Morena says, are you people not ashamed? Just go home and fight for your countries. Indeed, we are fighting, Comrade Luke Morena, but we also contribute to the South African economy. People that have been here for more than a decade, who are legal, by the way, should not be told just to go back. In any case, the Zimbabwean government also has a responsibility to create conditions for people to go back. We will, possibly tomorrow, talk about the meeting of the liberation movement, which is starting, I think today, starting today in South Africa, being hosted by the African National Congress. ZANU-PF is in attendance. So we'll talk about this tomorrow on what it means, particularly to the migrants from Zimbabwe in South Africa. Comrade Bulelwa Mutiwana, we see your comment. Comrade Tlakumbuyaza, Tlakumba, we note your comment as well. We note your comment, Comrade Lawrence Mahabo. We note your comments, Comrade Tai Im. You are saying, how far with the consultation? We have not heard anything because remember, the minister should be consulting holders of the Zimbabwe exemption permit. So no one has told us that they have been consulted. So this is why we're saying the minister might make a statement to that effect before the deadline of 28 November 2025. We suspect that he might make a statement. Uh, Comrade Mary Marange, you say, how can I apply for my kids? If your kids are born in South Africa, the first thing that you do, you apply for their Zimbabwean birth certificate. It will state that the child is born in South Africa. Then you get them the Zimbabwean passport. If they are uh, below school going age, you apply for their accompanying visas at the VFS. If they are already in school, you apply for their study permits. That's what is happening. But if then they are above 18, born in South Africa, they've continuously lived in South Africa, they can apply for a South African ID on condition that you, as the parent, you are also legal in the country. But if you are not legal in the country, it means they are not legal as well. Even if they were born in South Africa, they will not qualify. And also, if your child was born in South Africa but went to start in Zimbabwe, they do not qualify to apply for the South African ID because they did not continuously live in South Africa. Comrade Philmon Chikara, sorry if I pronounce your name wrongly. I got my waiver but is not opening. Was given an email address to lodge a complaint, but no response from that email. I wrote 3 times to the email. On Tuesday, as the leadership of the Zoom community, Tuesday next week, today is Friday, Tuesday next week, we are meeting with the officials at the VFS offices. We will then let you know those issues are part of the talking points that we'll have with the VFS officials. So we hope to give you an answer after our meeting on Tuesday. As Koli, we note your comments, Comrade Mandla Matau. Comrade Koli will also say, also me, I was rejected for my general work visa, not providing SAQA, but I did appeal. So as manje, we hope they are going to reconsider your appeal. Comrade Peter Murangai says, is 20 November a deadline for applying? What we know is that if by 28 November you have not applied either for a waiver or for any of the visas, by the morning of you will be assisted by the authorities. That is, you become a candidate for deportation. Comrade Edward Nene says, thanks, Comrade. I'm a ZP holder and I'm married to a South African. Where can I apply for a spouse visa? You apply at VFS for a spouse visa. Your partner earn less than 8,000. If your partner earns less than 8,000 rands, then you will not qualify. Comrade Tai M says, is it possible that they can complete the consultations within a month? I do not know. I do not know. And how they are going to carry out the consultations, I do not know. We note your comments, Comrade Peggy Masego. And thank you so much, all of you comrades that have joined. We are getting to the end of July. We will be getting to August soon, and the English football will start in August. I miss my Manchester United, Chelsea, Arsenal fans, so I hope we will enjoy this season. Otherwise, comrades, enjoy the rest of your weekend. Goodbye. Something went wrong. Thank you.